topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show, where we bring you the finest experts in the field of legal, health, financial, and home improvement. Hey, I got this show, which is the first Thursday of the month. I need to share something special. We went back. We have actually 56 shows we do each month. And we went back and looked at the numbers. And I got to tell you, this show here, our community association show, K-Bender Rimbaum, is our number one show. It gets more letters, more emails, more viewers, definitely more listeners than any show we do. And they do a show in Orlando and one in Tampa, and they are both in the top 5. But this show here is our number one show. Let me welcome to the star of the show, attorney Robert K.
Hello, Steve. Hello, everybody.
Oh God, your numbers just blow everybody away. And you know what? I want to tell people, listen, Robert has developed the most incredible community association law firm in the state of Florida. And this is one busy office. And he takes an hour out each month along with 2 of his other attorneys. And Robert, I got to tell you, we can't thank you enough for you giving your time like this to educate everybody.
No, we're happy to do it.
You're the best. So, you know what? I also saw that every month we're getting new people who found the show. And usually their email will say, I never knew this show existed. We've been doing the show for 12 years now, but that's okay. You found the show. So tell everybody about K-Bender Rimbaum.
Well, K-Bender Rimbaum, as you've said, is a firm that focuses on community association representation. We do so out of 4 offices: Pompano Beach, Palm Beach Gardens, Orlando, and Tampa. We cover pretty much the whole state in those 4 areas. We're able to do that. We were available electronically, as most things are these days. So it doesn't matter where we are. We're able to assist you in your association needs in all of Florida, be it reviewing governing documents, advising the board as to their rights and responsibilities, dealing with collection of unpaid assessments, contract negotiation, construction defect issues. We have a board-certified attorney in construction defect litigation. We have 10 attorneys who are board certified by the Florida Bar in community association law. So we provide significant legal specialization to the communities on these areas of their needs on a day-to-day basis.
You know, what we people who are just tuning in for the first time, what we do is we collect your questions. You send them to us at the Stephen at AskTheExpertsRadioShow.com, and we present these questions to Robert, and we've always got a ton of questions. One thing I must tell everybody Um, there are some new laws coming out. They have not been signed by the governor yet, and we're not going to get into those today. So if you have something about the new laws that are going to be coming out, let's stay away from those. We have plenty of time to talk about them once they're signed by the governor. Is that okay, Robert?
That's okay. When they are signed, a lot of them become effective July 1. So
Yeah,
it's on the
not,
horizon.
not a lot of time. So let's start off with Jesse in Boca. He said, I've heard I should be very careful challenging an ESA application. Is that true?
That is definitely true. ESA application is for an emotional support animal under the federal fair housing laws as well as the state fair housing laws. Emotional support animals generally are given great latitude and leeway, and associations are fairly limited in the inquiries they're able to make. We always recommend, if an association gets an inquiry for that, not to try and address it without involving your legal counsel in making that determination. It's You don't want to step in anything incorrectly, because the potential downside is like minimum of a $10,000 civil fine if you're found in violation and in a discriminatory fashion. It is considered discrimination if you wrongfully disapprove or interfere with the ability of an emotional support animal to reside in a no-pet community. So definitely need to be very careful when something like that is submitted.
Helen in Boca Raton, I love your show. My board and I listen every month. Investors are starting to take over the condo. This has become a real issue. They often promote huge assessments, forcing owners to sell out to developers. What do you suggest on how to keep these investors from taking over?
Well, there's a couple of ways that can be considered. One would be for the owners to amend their documents that limit the number of units that any individual or entity can own, directly or indirectly, which would, in some ways, eliminate somebody from coming in and buying up chunks of units and taking over that way. Another option to consider is, if you're getting a investor group that is taking on a larger percentage of the units within the condominium, they can be found to be what's called a successor developer. A successor developer is not allowed to take control of the board. The board would have to be controlled by non-developer entities or individuals, so that the investor group wouldn't be able to run the condominium and adopt large special assessments to force owners out. So those two methods are things that can be considered. I wouldn't do it without competent legal counsel assisting and addressing the situation, because there are technicalities involved in both choices with respect to limiting ownership and limiting leasing abilities. There are some hurdles that have to be crossed and administrative records that have to be kept in the amendment process that the council will help the board understand.
Okay, we're going to go to the chat line. David wants to know, what happens to board decisions, actions taken in an HOA with over 100 units if the board meeting is not posted in the website as required by new law?
Well, new law is not in effect yet, so
they're talking about the new law.
If we're talking about old laws, the board meeting happens without proper posting. That could be subject to a legal challenge, but it's also correctable by the board either properly posting a meeting and ratifying what it did previously, or it is something that the board can fix by a written resolution signed by 100% of the board members. So it's not going to be something fatal. And the only way to challenge it in an HOA is to file a lawsuit and ask the court to deal with it. There is no division of condominiums overseeing homeowners association when it comes to these types of issues. So if they have appropriate attorney assistance for the association, the likelihood of that being any real issue is pretty low.
Lowy in Pompano Beach is an HOA. Can we use general proxy at the annual meeting for voting?
Oh, HOAs are not prohibited from using general proxies. Only condominiums are prohibited from using general proxies for most instances. So for HOAs, the answer would be no, you can use them.
Okay. Jan in Davie, someone asked this question 3 or 4 weeks ago. What is a notice of commencement?
Notice of commencement is a term that goes under the state's construction lien laws that are found in Chapter 713 of Florida statutes. Construction lien law is a group of, it's some technical legislation that is geared to protect contractors and owners that are dealing with contractors, that being associations in our topic here, need to follow the provisions of the construction lien law to best protect the association from the possibility of paying contractor to do work and then finding out they didn't pay suppliers, they didn't pay subcontractors, and having to pay multiple times for the same thing. The notice of commencement is the first step in the process of having work done, and it's for anything that's over $2,500. It doesn't necessarily apply to landscape modifications, and there are technicalities involved, but in most instances of undertaking work on the condominium, a notice of commencement has to be prepared and filed in the public record of the county that the property's in, and then a certified copy gets posted on the property site during the course of the work. It triggers the rest of the statute coming into play relative to protecting the association from the potential of multiple payments for the same work. Part of that is a partial release form that has to be provided by the contractor when they're getting partial payments, where they identify that they've paid all their suppliers or identify those who have not been paid. It triggers what's called a notice to owner, which is a form that the suppliers and subcontractors send to the association to notify them that they have a claim against the project and that they need to be paid. And it's the association's obligation to make sure that they do before they're free and clear under the contract. And then the final step in the process is a notice of termination, which is filed in the public record when the project is completed, along with the contractor's final affidavit and release when payment in full has been made. So notice of commencement is the first step in the process, has pertinent information about the real property that's involved in and what the project is, who the contractor is, who gets notified. And there's a statutory form that has all that information. Right. It's also important that the association be aware that when contractors prepare notices of commencement for the projects that they're doing, they don't do them generally legally correctly. The property description is often incorrect. So it's important that the association have its own counsel prepare those documents for it so that it's getting the appropriate protection under the statute.
We just got a text in, which I think someone else has also asked a similar question. I guess with all these electric cars, people want to know how can they get their properties to put in more charging stations?
That's a question there isn't an answer to at this point. In condominiums, there is the requirement that if an owner wants to install a charging station on their own limited common element area or things they have exclusive access to the exclusion of everybody else in the condominium, they can do that at their own expense, subject to not damaging the property, and obviously the electricity has to be paid for by themselves. Most communities aren't in the practice of providing charging stations for the owners. You know, there is a cost involved in charging the vehicle, so there hasn't been legislation that I've seen that addresses that.
Okay. And by the way, we will be going to your long, busy schedule for June in just a minute. I'm going to get one more question in here. HOA, this is from Rex in Hollywood. This has been asked before too. What is an architecture review committee, and what are they allowed to approve or disapprove?
Well, the Architectural Review Committee is established by the Declaration of Covenants in an HOA or in Declaration of Condominium in a condominium. It's more prevalent in HOAs than in condominiums because alterations are generally not made by unit owners in the condominium unless it's within their units. While in HOAs, it's more for the exterior appearances of the homes within the community that are the responsibility of the homeowners. The purpose of the committee is to, whatever the documents say, and the documents are not the same everywhere, so you'd want to check in your own community to see, but in general terms, they either create the criteria that applies in reviewing and approving alterations to the property, or the board creates the criteria and the Architectural Control Committee will evaluate applications and issue approvals or not. There has to be specific criteria in place in order for them to fulfill their function. There's usually a time frame that they're given in the documents to evaluate an application or request additional information, or after which the application can be deemed approved in most instances, although some documents might say it's deemed denied if it's not approved in the time frame. So again, you got to review the documents on that point to determine what applies within a specific community.
Mona wrote us that since we're going to your schedule, love your show. I am so glad that you repeat your schedule for the month. I know I can go to your website always, but it's nice listening to your show, and I write your classes down. Your classes are wonderful. So since Mona is loving your classes, before we go to break, let's go to all your classes.
And they're not, I don't think they're all fitting on the scroll this month. So
I know you have a lot of classes.
There's a couple more that aren't being shown there. So starting on June the 10th at 12 p.m. to 1:30 p.m., there's an FLA, the Florida Legislative Alliance Legislative Update webinar. Michael Bender and representatives from the Florida Legislative Alliance will be presenting. It's hosted by the CAI Southeast Florida chapter. That's on June the 10th, 12 o'clock to 1:30 p.m. That's about going to focus on what was done in 2025. On June the 17th at 11:30 to 12:30 p.m., funding construction projects and construction contracts. Jeff Rembaum and Ben Haidloff from the Palm Beach Gardens office will be presenting. It's co-hosted by GRS Management. There are some CEUs for CAMs in this particular presentation. June 17th, 1 p.m. to 2:15, a legislation session update webinar. Michael Bender will be joining Campbell Property Management. There's no CEUs for this, but that's on the 2025 legislative changes. On June the 18th, from 11 a.m. to 12 p.m., Clear Communication, Stronger Communities, a webinar hosted by Affinity Management Services. Emily Gannon from our Pompano Beach office will be presenting. Also on June 18th at 6:30 p.m. to 7:30 p.m., Community Association Professional Roundtable, focusing on House Bill 913 and My Safe Florida condominium program. Michael Bender will be presenting at that particular event. It's hosted by Next Gen Management and Accounting Services. There are no CEUs for that. June the 20th, 11 a.m. to 2 p.m., HOA Board Member Certification webinar. Emily Gannon will present. It's co-hosted by Associa Management. On June the 24th at 11 a.m. to 3 p.m., there's a Condo Board Member Certification webinar. Kirsten Hentz from Tampa and Alan Schwartzide from Orlando will be co-presenting, and that's co-hosted with Empire Management. On June the 26th at 12 p.m. to 2 p.m., we have the 2025 Legal Update webinar. That's the changes that occurred in 2024. There are 2 CEUs for credit for management. Kirsten Hentz from our Tampa office will present, co-hosted by Rosetta and Company Management. And the last item on June 30th, 2 p.m. to 3 p.m., Association Matters on Insurance Requirements and Legislative Update webinar. Jeff Rembaum and Alan Schwartzide will be presenting, co-hosted by Lang Management. And there will be a guest from Plastridge Insurance also involved in that particular session. Busy month.
Yeah.
Considering it's summertime already.
No kidding. Hey, tell people how they can reach your office, which is actually good for all 4 offices.
All 4 offices. Call 800-974-0680. You can write to us at info@kbrlegal.com. Or you can go to the website, kbrlegal.com. There's a contact form on the first page of the website. You fill that out, and someone will get back to you.
Beautiful. We're going to go to break. When we come back, we have more with attorney Robert Kay of Kay Bender Rimbaum. We'll be right back.
Kay Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kay Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. Kay Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact Kay Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We're here with attorney Robert Kay Bender Rimbaum. Wow, the chat line it's really going crazy. Let's go to, is there a guideline template available for condo board members to use when trying to update their bylaws?
There is no such guideline template. It's general. What we typically do is our clients will reach out to us and ask us to review the documents and make suggestions. They may have some ideas of their own as to what changes they may want. The laws are changing on an annual basis, so that's something that needs to be taken into consideration. There's never been a uniform guideline created for such a document, and most communities have their own unique interests and desires. So usually, it is something that is customized for that particular community.
Okay, we're going to go to again the chat line. Jake, an owner in our condominium is a realtor who often represents buyers and sellers and owners and renters here. She has been president of the board for years, so has access to everyone's contact information along with other sensitive info. Isn't this a clear conflict of interest?
It's a potential conflict of interest. It isn't necessarily a clear one. Having access doesn't mean the access is being used. But what's important with these situations is that there be full disclosure by the board member of their dual roles relative to the community. And it sounds like that may be in existence based upon the question, identifying that the writer's aware of this particular arrangement. It's not an ideal situation given the information that the president may have access to, but if the individual's been on the board for years and president for years, it might be because that's what the community wants. So it really takes the unit owners to stand up and address it if it's a problem to them as a whole.
Cher in Fort Lauderdale, she has a condo. She wants to know, can a president of our board hold more than one officer's position?
Yes, the president cannot hold the office of vice president, obviously, because the purpose of the vice president is to step in when the president's not available. The president also cannot be the secretary unless that's the only officer in the corporation, because the secretary's function is to attest the signature of the president. So the president can also be the treasurer. That particular office doesn't have any conflict with the office of president. So the president would be able to serve in both capacities.
Here's one that even I could answer. I've been doing this for so long. Larry in Boynton Beach has got a condo. They have 145 units. He wants to know, do we need a CSRS reserve fund? Our building is 2 levels.
Well, the CSRS requirements are based on the number of stories you have, not the number of units. So if you don't have 3 stories, then you're not required to undertake the CSRS reviews.
Okay. Shelley in Miami, a couple bought into our association. Our documents say for a 1-bedroom occupancy is only for 2 people. Can an additional family member stay over 6 months, giving them 3 people? Can we enforce our restriction?
Well, assuming the association has uniformly enforced that restriction in the past, assuming there has been violations in the past, or if there's never been another violation, the answer is yes, conditionally. If the third occupant, depending on what county you're in, is under the age of 18 or other ages per county, they may not be considered a full person. So you need to check the county ordinances in the county that you live in. But generally speaking, so long as your enforcement does not have what they call a disparate effect on a protected class, and there will be families with children, it would be enforceable.
Going back to the chat line from Bonnie, if an ARC only acts on violations submitted by a member, is that selective enforcement if they did not receive a violation for a different member violating the same rule?
Well, it doesn't sound like a good practice if they only act on violations that individual members bring to their attention. They need to act uniformly on violations and enforce them the same against everyone. The issue with selective enforcement could be that the committee could claim, well, they didn't have knowledge of the other one and they only have to enforce what they have knowledge on. And that may or may not be effective in a court if that selective enforcement defense is raised. I suspect that in all likelihood, a court would not buy into that, would side with the owner raising the defense, because that is the tendency of the courts in the first place, is to view associations' enforcement rights very narrowly. And they would err on the side of the unit owner if there was any doubt. But the practice of this particular setup is one that should be changed so that there are steps that are taken and procedures in place to review the entire community and identify violations objectively and uniformly.
Jen in West Palm Beach wants to know, neither my condo docs nor rules and regulations prohibit pets. Our board has denied an ESA dog to one of the owner's renters. Can the board suddenly add in the rules and regulations no pets restrictions?
The answer to that is no. If there's going to be a restriction on pets within the community, that's something that has to first be found in the declaration of covenants or condominium, whichever it is. The board cannot make a rule that is in conflict with what the declaration provides. A declaration, if it's silent on the issue of pets, the presumption is it's unrestricted. So since it's unrestricted in the declaration, the board would not be in a legal position to make a rule that adopts a restriction. So in a community that has no pet limitations, there should be no need for an ESA application, because pets alone aren't restricted. Not that ESA are considered pets under the law, but there would be no reason to have to submit application, I would think.
Joe in Pompano Beach wants to know, can a board refuse to Zoom a meeting to avoid having to record it?
Well, Zoom is not mandatory. That's something the board can do if they choose. So if the board chooses not to have a meeting by Zoom and wants it just in person, the board has the power to make that decision, whatever their reasoning is.
Okay. Stephen in Boca Raton, our board refuses after repeated requests to enforce our rules and regulations. What can we do about this?
Well, the most basic step that the owners can take is to put in a board that will do what they want, either at the next election or by recall, whichever is more timely for them. If the annual election isn't for some time yet, then recall might be a better approach. Another alternative is to bring legal action against the community for breach of fiduciary duty of the board members in failing to uniformly enforce the governing documents. The problem in doing that, though, is that there's an expense involved in hiring a lawyer and bringing a lawsuit. The likelihood is the lawsuit would get referred to the association's insurance for defense. Or if the insurance does not cover it, then the association has to pay its own lawyer to defend. So owners are paying on both sides when that happens. And so that's typically not the best choice. The only other likely possibility would be, if it's a condominium, to bring it to the division of condominium, and whether or not they do anything on that is a coin toss. So the number one way to address that is replace the board.
Okay. Luke in West Palm Beach wants to know, how much time do you get to spend a special assessment? What happens to leftover funds from a special assessment?
Do we know HOA or condo?
It doesn't say. Figures. Must be someone new.
Well, in condominiums, it provides that once the need for a special assessment has been completed and the project is done, any excess funds become what's called surplus and can be either returned to the owners or used to offset future assessments. The way that's done is the board just applies it to its expenses and reduces the assessment obligations of the owners going forward. There is no specific time limit on spending the funds so long as the purpose of it hasn't been completed. So let's say you have a construction project that takes 2 years to complete. You're holding the funds for the whole 2 years until you're done paying or you're done with the work, and then you pay whatever the amount is if there's any left over. Same issue. There's no statutory provision for leftover funds in HOAs, but under general accounting principles, that would likely just become part of the operating funds of the association.
Chris in Boynton Beach wants to know, this is a condo, wants to know if the condo board voted on and signed a contract with a contractor to complete a multi-million concrete restoration project over the next 2 years. Can members petition to stop the work?
Well, a member position would have no legal effect. The board has the power to make that decision. So just a petition to stop the work isn't going to stop the work. The only way to stop the work is change the board. The fact that there's an existing contract in place that would expose the association to potential claims for damages of breach of contract with the contractor, which can be significant. So the likelihood of being able to stop such work is fairly low. Another alternative, if there are grounds for it, is a lawsuit can be brought to get a temporary injunction or possibly permanent injunction to stop the work, but that's a pretty high bar to cross on what you'd have to prove relative to the work and how you're going to challenge that. It's very unlikely to be successful.
Norma in Boca Raton, she is a board member. Thank you so much for giving such great information. I would like to know, can we take Kaufman language out of our declaration?
Well, Kaufman language, for those who may not know, is a specific provision that incorporates changes to legislation that may occur down the line. And so the language says, whatever statutes involved, say it's Chapter 718, as amended from time to time, is the Kaufman language, which would incorporate changes that are made to substantive provisions of the statute in future years. Once you have that in there, everything in the statute is applicable. If you amend to take it out, then the likely effect of that would be that whatever the statutory provisions were in place when you removed it and recorded that amendment would be what applies to your community. So you would no longer be bound by future changes, but everything that's happened so far would apply.
Okay. You know what, Lee, we've got about 10 minutes left. Can we go to your schedule again?
Let's do that schedule.
Let's do it.
So starting with June the 10th at 12 p.m. to 1:30, the Florida Legislative Alliance is hosting the FLA Legislative Update webinar. Michael Bender with representatives from FLA will be hosted by CAI, Southeast Florida Chapter. June 17th, 11:30 to 12:30, 11:30 a.m., 12:30 p.m. Funding construction projects and construction contracts webinar. Jeff Rembaum and Bed Haidloff from our Palm Beach Gardens office, co-hosted by GRS Management. There will be CEUs for CAMs on this one. June 17th, 1 p.m. to 2:15 p.m. legislative session update webinar. That's on the current bill 913 that everybody's talking about. Michael Bender will be presenting. It's hosted by Campbell Property Management. June the 18th, 11 a.m. to 12 p.m. Clear Communication, Stronger Communities webinar. Emily Gannon from the Pompano Beach office will be presenting. It's hosted by Affinity Management Services. On June the 18th at 6:30 p.m. I'm sorry, that previous one was also June 18th. June 18th at 6:30 p.m. to 7:30 p.m. Community Association Professional Roundtable, House Bill 913, and the My Safe Florida Condo program will be the topics. Michael Bender will present, hosted by Next Gen Management and Accounting Services. June the 20th, 11 a.m. to 2 p.m. They'll have an HOA board member certification webinar. Emily Gannon from Pompano Beach will present, co-hosted with Associa Management. June the 24th, 11 a.m. to 3 p.m. We have a condo board member certification webinar presented jointly. Kirsten Hentz from Tampa and Alan Schwartzide from our Orlando office, co-hosted by Empire Management. June the 26th, 12 p.m. to 2 p.m. The 2025 legal update, which are the changes from 2024. That will be hosted by Kirsten Hentz, co-hosted by Rosetta and Company Management. There are 2 CEUs for managers in that one. And on June 30th, 2 p.m. to 3 p.m., Association Matters on Insurance Requirements and the Legislative Update. Jeff Rembaum and Alan Schwartzide will present, co-hosted by Lang Management and a special guest from Plastridge Insurance. You can go to our website at kbrlegal.com, click on the calendar to register for whatever event that you choose. Be sure to do so, so you'll get the Zoom information. I think these are all on Zoom this month, so you want to make sure you register in advance so you are able to participate.
Going to our chat line, how long is a lien against a condo unit?
A lien is good for 1 year.
And how long is a lien against a condo unit valid for to recoup assessment fees?
How long is it valid for? Is 1 year.
Yes. Okay.
It can be renewed, but action has to be taken within that 1 year in a condominium.
Okay.
HOA does not have a time frame, so then it'd be perhaps 5 years based on a contract.
Trish in Delray Beach is an HOA. We received notice that we are faced with a special assessment to replace clubhouse and reserves. Is there anything in Florida statutes on how much the amount can go up to?
On a special assessment?
Yes.
No, there is no limitation. The association is obligated by law to assess for its needs. So whatever those needs are, that's what the association has to assess.
Okay. Luke in West Palm Beach wants to know, we love your show. Our entire board never misses your show. HOA annual budget meeting. When should advance notice be made? Annual meeting, how much notice?
Well, you want to check your governing documents because that may have time frames for doing that. My recollection on HOA budget notice, I'm trying to remember if there even is one. I'm thinking there is no specific time frame of notice requirement in an HOA for the budget meeting. It's a good rule of thumb to give a 14-day notice to the owners of doing that, but condominiums require the budget to be included with that notice. So Annual meeting is going to be based on your governing documents as far as the time frame for giving notice on that. Generally speaking, no less than 14 days notice.
Eric and Delray, this is one of those I bet I know the answer to. Kind of sad. $70,000 special assessment on our condo. The most of us can't come up with the money. We can't borrow any more money. Can they evict us?
Well, no one gets evicted without a foreclosure happening first. And if a community is in that condition, it's unlikely that the association is going to be able to afford to file lawsuits to foreclose on everybody if nobody can pay. So they're going to have to come up with a different plan. If somebody doesn't pay their assessments, they are subject to lien and foreclosure. And if the association takes that step and actually forecloses on the unit, depending on who buys it at the final foreclosure sale, quite often it goes to the association. The association can cause the removal of the occupants from the unit. It's not exactly an eviction, but the same effect.
Liz wants to know if the board of directors does not want to create a finance committee, can the owners still create their own finance committee without the approval of the board?
Well, whatever the owners do will have no legal effect. So they can create any committee they want, but they can't compel anybody to do anything about it. So it might not do them any good.
Yeah, Robert, we've got a few minutes left. We have a lot of board members out there that are listening to the show. No one can do this any better than you. Tell people why they should use your firm.
Well, the primary reason to use our firm is our expertise in the field. As I mentioned earlier, we have 10 board certified attorneys by the Florida Bar who are specialists in community association law. We have one who is board certified in construction defect litigation. It has always been our policy to provide comprehensive and understandable opinions to our clients in a cost-effective manner. Attorneys are not inexpensive as a rule, but we're always mindful of our clients' limitations when it comes to their finances. And it's also important to us that we provide the services that the clients expect in a timely and cost-effective manner. And that's the main selling point. We're reachable, we're accessible, and most importantly, we're understandable. And I think that's been a big factor in the growth of the law firm over the past 35 years.
Tell people how they can reach your office.
You can reach us at 800-974-0680. You can write to us at info@kbrlegal.com. You can go to the website, kbrlegal.com, and click on the contact box and fill out the information, and we'll get back to you.
And as always, if you missed part of today's show, you can go to YouTube, you can go to Spotify, you can go to iHeart under Ask the Experts, Condo, and HOA, Community Association for South
And
Florida.
you can go to kbrlegal.com and find it there.
That's right. Robert, thank you so much. I love doing the show with you. I'll see you next month.
All right. Have a good one, everybody.
You too. That's Robert K., attorney Robert K. Bender Rimbaum. Hey, thanks for all your notes. We tried to get to as many of them as we could today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.